Good afternoon, friends. Let us dive into another case law which has been newly added into the syllabus of Supreme Court Bar Association. Supreme Court Advocate on Record Association. Friends, this case is State of Punjab versus Davinder Singh, which was decided on 1st August 2024. Honorable Justice, Chief Justice D.Y. Chandrachud, Honorable Justice B.R. Gavai, Honorable Justice Vikrant Nath, Honorable Justice Bela M. Trivedi, Honorable Justice Pankaj Mithal, Honorable Justice Manoj Mishra, Honorable Justice Satish C. Sharma were members of the bench. The question before this bench was whether the sub-classification of scheduled castes for providing reservation is allowed under the Constitution of India, whether the states have the power under Article 15 and 16 of the Constitution to subclassify SCs. This was the issue. Now coming to factual background, French Article 341, subclause 1 of the Constitution of India grants the President the power to notify the castes, races, and tribes which shall be deemed to be SCs in a state or a union territory. Further, Article 341, subclause 2 states that Parliament can include or exclude any caste, race, or tribe from the list of SCs in the President notification. Various laws and schemes provide reservation in public employment to individuals from SCs. Now coming to Section 4, Subclause 5 of the Punjab Act, which provided that 50% of the vacancies of the SC reservation shall be offered on first preference to Valmikis and Majvi Sikhs amongst the SCs. On 29th March 2010, Honorable High Court of Punjab declared Section 4, Subclause 5 of the Punjab Scheduled Castes and Backward Classes Reservation in Services Act 2006, shortly Punjab Act of 2006, unconstitutional by relying on Chinna's case. In Chinna's case, a constitutional bench of the Supreme Court, which was of 5 judges, held that subclassification amongst SC by the states is unconstitutional because, firstly, SCs constitute a homogeneous class. Secondly, subclassifying them would amount to tinkering with the presidential list under Article 341 of the Constitution, which only Parliament can do so. And thirdly, the rationale of 9-judge bench in Indira Sane case, which permitted subclassification of OBCs, does not apply to SCs. On 20th August 2014, a 3-judge bench of the Honorable Supreme Court adjudicating the validity of Punjab Act referred the correctness of Chinna's for consideration by larger bench. On 27th August 2020, in the state of Punjab versus Davinder Singh, a constitutional bench of 5 judges held that the judgment in Chinas require reconsideration by a large bench of 7 judges. Several appeals which challenged similar sub-classification made in reservation policies of the state of Haryana and Tamil Nadu were also tagged with the challenge to the Punjab Act matter. A 7 judge bench was constituted. Now, coming to the decision of the Supreme Court, the 7 judge bench, by 6-1 majority, held that it was permissible for states to subclassify SCs when providing reservations. Honorable Chief Justice Chandrachud authored a plurality opinion for himself and Justice Misra, Justice Gwai, Justice Mittal, Justice Nath, and Justice Sharma. Each authored separate concurring opinion. Justice Trivedi wrote a dissenting judgment which found subclassification to be impermissible under the Constitution. Now, coming to reasons for the decision. Firstly, subclassification permitted by Indra Sane decision. The majority held that the judgment of the 9-judge bench in Indra Sane case did not create any bar on the subclassification of SCs because subclassification of SCs was not an issue in that case. Further, the majority ruled that Indra Sane is in fact utilized the principle of subclassification in the context of OBCs to ensure meaningful and substantive equality was achieved where the various constituents within a caste group were not comparable. Now, Justice Trivedi's dissenting opinion found that court in Indra Sane specifically excluded SCs from the scope of its judgment and that the decision could not be interpreted as permitting subclassifications. Now, Supreme Court under Article 341 do not constitute a homogeneous class. I am repeating the line. SCs under Article 341 do not constitute a homogeneous class. The majority traced the observation in Chennai that SCs are a homogeneous class to an earlier decision of N.S. Thomas case. The majority observed that N.M. Thomas merely observed that SCs once notified by the President cumulatively constituted a distinct class vis-a-vis the general category individuals. However, N.M. Thomas did not say that SCs are homogeneous class which cannot be further subclassified. The majority observed that Article 341 states that once a caste is notified as an SC by the President, such a caste shall be deemed to an SC. The inclusion of a caste within the SC category is only to demarcate them from other castes which are not included in the category. This inclusion does not automatically lead to the formation of uniform and internally homogeneous class which cannot be further classified. Inclusion does not mean the existence or non-existence of internal differences among the SCs. It only means that each of the groups that are included in the list will receive the benefits that the Constitution provides to the SCs as a class. Now, state legislature has the power of subclassification under Article 15 and 16. Why this is explained in this para. The majority observed that Article 341 subclause 2 grants Parliament the power to include or exclude groups from the President's list. This is the power that has been reserved for Parliament and denied to the states. A state legislature cannot add or remove groups from the President's list of SC. However, subclassification within the SCs for reservation does not include or exclude any caste or group from the President's list of SCs under Article 341. Subclassification does not lead to exclusion of any caste which is already in the President's list. Therefore, as long as a state that does not include communities not in the President list of SCs or exclude communities that the President has designated as SCs, the state does not violate Article 341 subclass 2 when subclassifying. The majority held that historical evidence confirms that inequality exists within the SCs. Therefore, there is an intelligible way to differentiate between various castes within the SCs. The majority held that if the SCs are not similarly situated, then the states cannot be prevented under Article 15, 16, and 341 from applying the principle of subclassification amongst the SCs. Justice Trivedi's dissenting opinion ruled that although various castes had experienced differing levels of historical discrimination, once they were included in the presidential list under Article 341, they become a homogeneous group. As a result, any form of subclassification within this group was not permissible. She also concluded that the states lacked the legislative authority to create such subclassification, and neither the states' lawmaking power granted them the power to do so. Criteria for subclassification. The majority found that the purpose of reservation clause in the Article 16 subclause 4 of the Constitution is to remedy the inadequate representation in public service of certain classes, which have been inadequately represented because of their backwardness. The question is not whether certain sections of the society are a numerical minority in the state administration, but whether groups are inadequately represented because of their backwardness. Further, meaningful representation would not be fulfilled by SCs occupying numerous lower grade posts, but must be assessed across all posts, including senior posts. The majority held that the states can identify inter-se backwardness amongst SCs through empirical data based on inadequacy of effective representation. However, it must be proved that inadequacy of effective representation of a caste is because of its social backwardness. The state must prove that the group caste carved out of from the larger group of SCs is more disadvantaged and inadequately represented. The decision of the state for subclassification would be subject to judicial review. The majority cautioned the states that they cannot adopt a policy of reservation which would allocate seats separately for each caste. It reasoned that This is because the socially backwardness suffered by each caste is not so distinct to give a reserved seat to each class separately. It ruled that two castes will have to be grouped together if their social backwardness is comparable. Applicability of creamy layer principles to the SC. A majority of the court held that certain castes have been reaping benefits of reservation more than others. Therefore, states must evolve a policy to exclude the creamy layer of the SCs, STs groups from the benefit of reservation. It also held that the creamy layer principles also apply to SC. However, the criteria should be different from that which is used for the OBC reservation. However, Justice Bella Trivedi, in her dissenting opinion, stated that SC/ST groups are already categorized as a backward class of citizens by the President's notification. Consequently, the concept of excluding the creamy layer cannot be applied to them. Dissenting current referral lacks sufficient reasoning. Justice Trivedi, in her dissenting opinion, ruled that the three-judge bench's decision to refer Chennai to a large bench was inappropriate and not in consonant with the doctrine of precedent and judicial discipline. She further held that the referral lacked sufficient justification for doubting the reasoning in Chennai. That's all, friends. God bless you all. See you again. Don't forget to subscribe and share. I am spending a lot of time from the early morning to late evening and always in your service.